The coins alert is where everything in this video comes from. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. Ripple sends in Form C, an SEC case that focuses on 4 main problems. Before we go any further, there is a new crypto airdrop going on Telegram right now. It will soon be over. Make sure that you take part in this airdrop. Just below the movie, there is a link. Do not miss this. Let's watch more of our movie. By filing its civil appeal pre-argument statement, also known as Form C, during the process, Ripple Labs has made its legal fight with the U.S. Securities and Exchange Commission even stronger. The Securities and Exchange Commission filed an appeal against several parts of a decision that was made public not long ago. The company found that selling its own cryptocurrency, XRP, to individual investors through a computer program did not break any U.S. securities rules. The Cryptocurrency Payments Corporation gave the Second Circuit Court of Appeal 4 important questions to think about in its statement, which was sent out on X by attorney James K. Phelan and included important points of difference. We need to first find out if an investment contract under the Securities Act of 1933 needs to be in writing, include tasks after the sale, and give buyers the right to get profit from sellers, what it means. To do business with digital goods might be very different after reading this description. A second point of disagreement is that Ripple is questioning the lower court's ruling that its XRP transfers met the standards set in the SEC v. case. Because of this case, which led to the creation of the Howey test, the requirements for something to be called an investment contract were laid out. This is Ripple's point. Its transactions were not an investment of money in a common business with rewards expected only from the work done by the company. As part of the civil appeal, Ripple has sent in the pre-argument statement Form C. The business is questioning a part of the decision summary from 2023 that said institutional sales of XRP were the same as unregistered security offers. Also, the U.S. regulator has sent in Form C. CU, which is an appeal against the ruling that retail sales of XRP did not break US federal laws about issuing securities. When it came to XRP sales, the company filed its pre-argument statement for the civil appeal in 2023. In it, it argued against a part of the court's ruling summary. Institutional sales of XRP are being fought by Ripple as stocks that have not been registered. Because of the decision we made, District Judge Annalisa Torres, both Ripple and the SEC had some success. According to the decision, XRP that was given to regular buyers was not a security in and of itself. Still, the court decided that Ripple's sales of XRP to institutions were the same thing as offering the coin as unregistered securities. Ripple wants to fight the decision that caused them to lose some money. Mr. Stuart Alderity, Ripple's top legal officer, said he was sure that the company would easily win the lawsuit. In an interview with Fox Business, the lawyer said he was happy with Ripple's filing. This comes after the U.S. Securities and Exchange Commission filed a civil appeal pre-argument statement form against the company. A civil appeal has been sent by the Commission to the courts in the United States to overturn Judge Annalisa Torres' summary ruling. Eleanor Tourette, a writer for Fox Business, said that the Commission is looking into the company's automatic sales of XRP-owned cryptocurrency trading sites and the help that Ripple employees are said to have given to the transactions. The reporter also said that the Commission's response is an attempt to shed light on how Ripple distributes XRP shops. Another thing Tourette made clear was that the U.S. Securities and Exchange Commission is not fighting the $125 million fine either. Both Alderity and Garlinghouse are sure that they will win the case. Also, Aldo said that the Commission is not disputing the judge's decision about whether or not XRP is a security. He also said that the judge's decision is the law of the state. According to a post on X, the lawyer said that the main goal of the U.S. Securities and Exchange Commission is to distract and confuse the XRP owner and the whole cryptocurrency industry. In his answer, he said that Ripple's business will keep growing even as the legal process makes progress. Brad Garlinghouse, CEO of Ripple, told Eleanor Tourette that he thought the blockchain business would be successful. In an interview, it would be a big setback for Gary Gensler, the head of the Securities and Exchange Commission, if this happened. Gensler is trying to control cryptocurrencies. The boss who took over after Garlinghouse said that banks were staying away from crypto people and businesses. The news that this happened was a big change. Garlinghouse told the crowd at FinTech Week in Washington, D.C. that Citibank had closed his account because of his work in the cryptocurrency industry. 25 years of working together came to an end with this. Besides that, the San Francisco-based business brought up a third important issue related to fair notice. The company says it gave people who wanted to buy XRP a lot of information that showed how confusing it is for people to understand how federal laws apply to cryptocurrencies. This claim is very important to Ripple's case because it suggests that the Securities and Exchange Commission seat and other related agencies did not do what they were supposed to do and give clear guidance on in its brief challenge. Ripple's last question is about the clarity that is needed by the federal rules of civil process in order to issue injunctions. This company says that Judge Annalisa Torres's order, which came along with a $125 million fine for the firm, only tells it to follow the law and doesn't give it enough specifics and clarity. This is Ripple's strategic point of view. In a statement released after the filing, the company's chief legal officer, Stuart Alderati, made it clear that the current lawsuit is not about whether or not XRP is a security in general. He said that XRP is currently seen as a non-security, just like Bitcoin DTEX. This was an opinion that the Securities and Exchange Commission did not disagree with in its Form C entry the week before. The lawyer says that this is how Ripple was able to focus its arguments about how to classify cryptocurrency and how to use it. The experts think that since both sides of the case have already given their briefings, it is now up to the second court to make a scheduling order that will make things easier. Alderati says that the court will only look at the record that already exists. This means that new information will not be allowed to be brought into the process. This could cut down on the number of interruptions and speed up the process of making a choice, according to the lawyer, because of an important decision that was made against it. Ripple Labs has finally sent in a notice that spells out the specific parts of its case that it wants to appeal. Attorney Jeremy Hogan gave information about X and went into more detail about the big issues that are at play in this appeal. The information given is not meant to be taken as trade advice. Any purchases made based on the information on this page are not the responsibility of the people who made them. Before making any investment decisions, you should definitely do your own study and talk to a professional who knows what they're talking about.